Sharon, can we mute everyone who isn't me?
I'll just do a very quick to say hello to everyone who's joined this afternoon. This is part 3 of the Children's Rights Group, Children's Rights and the Law in the Time of Coronavirus. Just to anyone who hasn't used Zoom before, you will notice that you are muted and your cameras are off. That is intentional, just to avoid any background. For this webinar, we're going to ask that you use the Q&A function, please, to send any questions through to the panel, and they will deal with them at the end of this afternoon's talk. Thanks.
Sorry, let me start again. Thank you all very much indeed for joining us for what is now the third episode in our series of webinars on children's rights in the time of COVID-19. As you will know, the webinar series has been hosted by the Children's Rights Group based here at Doughty Street Chambers. Today we are focusing on the issue of children's rights, COVID-19, and essentially children in contact with the criminal justice system. This follows on from two previous seminars, which have looked at a whole range of different issues, which obviously tie in to some degree with what we will talk about today. Previous seminars have looked at the impact of COVID-19 and government responses to COVID-19 on disabled children, children's immigration and asylum applications, child abuse, domestic violence. We've also looked at the changes that we've seen made post-COVID to the safeguards and regulatory frameworks for children in need, child protection, and the right to education. And these seminars, for those of you who haven't joined us before, are all available on the webinar website. So please do take a look at them if you're interested. You will see that I have put in 2 links into the chat. One of these is to the webinar website, and the other one is to the Doughty Street Chambers Insights website, which is where members of Chambers provide expert insights into particular aspects or particular issues in terms of the law. And there's a growing amount of work there around children's rights in the time of COVID-19. So I'd strongly encourage you to visit there if you would like further information. Now, I'm conscious of time. We have 3 superb speakers today, and I'm delighted to see that this is complemented by a really interesting, wide-ranging audience with experience in the topics that we are going to talk about today from a practice, policy, advocacy, and academic perspective. And this bodes really well for an excellent discussion today. And what we're focusing on today in particular is the challenges faced by children in contact with the criminal justice system, whether under arrest, whether in a prison, in a detention context, you know, whether cautioned, etc. And our speakers will focus on different aspects of work around this. I want to start, however, by just very quickly outlining how today will work. So, for instance, I think it's worth noting that each of the speakers are going to speak for 8 to 10 minutes in order to maximize the opportunity for Q&A following the presentations. Can I ask from this point onwards that if audience members have questions, if you have comments, please pop them into the chat box at the bottom of the screen. Okay, so submit them. We will not be turning on mics, but we will certainly be, presenting your questions to the panel to respond. So please do make sure to put them in the chat box at the bottom. So, enough from me. I now want to turn to the first of our speakers today, who really needs almost no introduction at all. Kirsty Brimelow QC, who heads up our international human rights team here at Doughty Street Chambers. Kirsty has in-depth practitioner expertise in criminal law, public law, international human rights law. Amongst other accolades, she was the winner of the first 100 Years Inspirational Barrister Women in Law Award in 2018. And in the same year, winner of the Advocate International Pro Bono Barrister of the Year. From a child rights perspective, Kirsty has done an awful lot of work in a training context internationally, and she has also in recent years represented children accused of the most serious offences. Crucially, for today's event, Kirsty has worked with another colleague at Doughty Street Chambers, Pippa Woodrow, to produce a hugely useful and detailed guide to criminal offences under the lockdown regulations and Coronavirus Act. Again, I'm going to put this as a link into the chat now so you can consult it after the event. But now I would like Kirsty to speak to us and to provide an overview of children and emergency policing powers in the time of coronavirus. Over to you, Kirsty.
Thank you. Thank you very much for that introduction. I'm going to really give it is an overview, but I'll probably duck in the regulations where they're more specifically relating to children. And one thing, apologies in advance if the slides become increasingly blocked with different colours, because I've tried to make some distinctions with the different amendments to the regulations. The first point is that the regulations that came into force are for the 4 nations. And so, sorry, I'm just losing control of my screen there. The England regulations are the ones that I am going to focus upon. And they came in on the 26th of March 2020, and then they were amended on the 22nd of April 2020, and then subsequently on the 13th of May, and then the most recent has been the 1st of June. They're going to change again, of course, next week. But so what I've done is I've really looked at what we can see there are going to be the main regulations that impact in the past, because some cases which have engaged those regulations are still coming through the system. I'll give an overview on where we're at now and some points on powers, how perhaps they're being disproportionately used in relation to young children and young people. So the Coronavirus Act, you can see at the bottom of that slide there, it is an act which I'm not going to talk about today. That has powers to really assist the public health officials who are dealing with potentially infectious persons. And those powers are predominantly set out in Schedule 21. Now that is primary legislation, so it expires on the 24th of March 2022, but it must be renewed every 6 months. The emergency regulations, what is important is that they come in under the Public Health Act 1984, and with any secondary legislation it has to be virus, so it has to fit within the purpose of its enabling act. And you can see the purpose of the enabling act there as being preventing, protecting against, controlling or providing a public health response to the incidence or spread of infection or contamination. So of importance is that these powers are not for public order purposes. They are to prevent, protect against, and effectively to contain the spread of coronavirus. And that's actually emphasised within the regulations themselves. And I set out there Regulation 3, where it says that where any of these restrictions are no longer necessary, to the same wording, prevent, protect, and so on, then the Secretary of State must publish a direction terminating that restriction or requirement. The Secretary of State is the Secretary of State for Health. A nod to the other nations is that at this time, the 26th of March, The other nations brought in very similar regulations, identical in Scotland as they then were. There was a difference in Wales in that the restriction on exercise was restricted to 1 hour. There was never a restriction on time, or in fact where you carried out your exercise in England, or I believe in Scotland. Northern Ireland as well were identical to the England regulations. The purpose therefore always has to be borne in mind when you're considering the use of enforcement, and that was just me playing with the graphics. Regulation 6 has been completely replaced, but up until the 1st of June, 11:30 a.m, this was what it said. It gets a little bit complicated because I've added in red the amendments that came in on the 22nd of April. And basically, for Regulation 6, it was added in there that no person may leave or be outside of the place where they were living without reasonable excuse. That was Regulation 6.1. Regulation 6.2 then set out a non-exhaustive list of 13 reasonable excuses. And you could see that they're non-exhaustive because of the word includes. The list of reasonable excuses in red, remember, are editions that came in on the 22nd of April. I haven't added in specifically for the 13th of May, that they're not particularly relevant to the matters that we're dealing with today concerning children, but they're fairly familiar because what we had in those early weeks was overreach, or at least signalling from the police that they were going to overreach. And hence we had the use of drones in Derbyshire, and we had fairly unwise pronouncements from police chiefs, such as in Northamptonshire, that they were going to be actually looking in people's shopping trolleys to see if they were using basic necessities. So the reasonable excuses are always well to bear in mind what they were originally. M was always an important one and is carried through: to avoid injury or illness or to escape risk of harm. And there were specific provisions concerning children who were not living in the same household as both of their parents, and that was in J. Again, that carries through. The major amendments, however, is that the prohibition now is not on going outside, it's on what you're doing inside. And so the prohibition relates to staying overnight at one place other than the place where they are living. So a person can now be outside for any reason. However, the new list of reasonable excuses are for staying away overnight. And they include some additions, including where it's reasonably necessary to stay elsewhere to obtain medical assistance. That might be in response to the Cummings case. And similarly, this might be another one in response to the Cummings case, where P is unable to return to the place where P lives, P for person, because the place where P is living is not available to P for any other reason. So I suppose you could say, my home wasn't safe for some reason, demonstrators or whatever. So there was a few quite interesting additions. Regulation 7, now the light blue, those of you who are still keeping up, is to alert you to the 1st of June changes. And this is a whole shift which wasn't flagged up in advance, that suddenly we can all do whatever we like outside, but inside, this is where the focus is. And so Regulation 7, which related to gatherings, was catching a lot of young people who were being detained or for being part of an illegal gathering. Regulation 7 now has been completely replaced from the 1st of June, and it sets out that no person may participate in a gathering which takes place in a public or private place, outdoors and consists of more than 6 persons, or indoors and consists of 2 or more persons. There's then an exhaustive list a finite list at Regulation 7.2, which incorporate exceptions. Work purposes are included. So in fact, a whole bunch of us could meet indoors for work purposes. We don't in fact need to do this Zoom conference anymore, but there are other restrictions. As always, a lot of it's completely illogical, and the initial restrictions also were fairly illogical. I'm going to skip over the children is Regulation 8. Again, the focus has changed from outside to staying overnight. That's where the enforcement is. And looking at offences and penalties, they can be enforced by police or relevant person, and this includes a person delegated by the local authority, still within Regulation 9. And within Regulation 10, that remains the same, that the person, the police relevant person, may issue a fixed penalty notice. What changed on the 13th of May is the level of the fine. And so it increased to £100 for a first fixed penalty notice, and it can double each time up to £3,200. There are a lot of concerns that fixed penalty notices have been disproportionately targeting children and young people and perhaps have been unlawfully issued. So hopefully we'll come back to that to discuss further, but there's the overview. Thank you.
Thank you, Kirsty. That was absolutely fantastic, and has really set the scene for the next two presentations. I think there will certainly be questions coming back to that, and I know that there are further details that you will share during the Q&A in terms of how the regulations have worked out in practice. But for the moment, I think it's probably sensible for us to move on to our next speaker and then take the questions in a round. But thank you so much for that fantastic kickoff. Our second speaker is going to be Maryam Mir, again, a colleague of ours here at Doughty Street Chambers. Maryam has very wide-ranging criminal experience indeed. Amongst her many professional achievements, she has defended cases in areas such as conspiracy to supply firearms, politically motivated offending from terrorism to Extinction Rebellion protests, serious violence, sexual offences, drug supply, and she, in addition to this, has worked with Reprieve on several high-profile terrorism cases. Today, she's going to speak to us about the challenges of representing children and young people in the criminal courts during the lockdown. So moving very much from the regulation to, I suppose, the day-to-day practice, as it were. So take it away, Maryam.
Thank you very much. I'm going to try to keep away from the law as much as possible in my presentation and just try to give you a view from the bar about some of the hurdles that I have been facing in the last couple of months when representing young people before the criminal courts. I'm going to focus mostly on the lower courts and the Magistrates' Court in particular, as well as first appearances for youths in custody, because this is where I have seen the most chaos and come across the most hurdles. The Crown Court has been relatively smooth, and I have found that in relation to pre-trial preparation hearings, sentencing and other mention hearings, I've actually had quite a smooth experience. But the Magistrates' Courts remain chaos, and it's there that I think I have got some tips and tricks for other people who may be in similar positions, and also just to let you know that the issues that I have faced. So I think the first thing to say is that preparation is absolutely key to overcoming some of the most frustrating hurdles that I have experienced. There is a massively extra burden on solicitors who are trying to facilitate these hearings. And what I have found is that taking on some of that by trying to ensure information is received directly to me rather than via the solicitor often makes things run a lot smoother. One of the things that I have found is that you may be given a link to the court seconds before the hearing rather than in advance. There's no clear information about where to obtain your papers from. You may find that there are 10 other cases listed at the same time as yours and you're in a long queue with no certainty for the defendant on how soon their case is going to be heard. And so some of the things that I have found really effective in overcoming those hurdles are figuring out where the child is being held early on. So if they are in custody at a police station having been held overnight, calling up the police station directly myself, speaking to the custody sergeant and arranging a time to have a conference with the young person ahead of the hearing. Secondly, I've put the email addresses there for anybody who finds themselves in this situation to contact the CPS directly and obtain papers. Ordinarily, all of this would be done in person, but of course, because we're doing them remotely, there are 2 email addresses that I have found very responsive to obtaining papers, and I do that directly myself to try and save some of the hassle for those instructing me. There are also online forms that need to be completed ahead of the hearing, and I tend to have those already prepared, having looked as soon as I receive the papers, fill those in with the client. Secondly, in terms of contact with the court, you will be provided with an email address for the court. I've given an example of one that I have, the CVP Thames, which is for Thames Magistrates Court. But often you will be given the wrong courtroom number, you'll be given the wrong link, there'll be lengthy delay in actually getting heard. And so I have found that emailing the court first thing in the morning at around 8 AM and letting them know who I am, who I'm representing, and what the issue is relating to means that I am on the radar of the court well in advance of the hearing. The second issue that I have found challenging is communication. Now, ordinarily, when you are representing young people, the ability to just exude reassurance by your physical presence and develop a rapport is severely hampered. And so I have found that I have had to use several different techniques when talking to young people who are in custody to overcome that physical distance. And an icebreaker is absolutely key because it means that the immediate laugh that you get together just breaks the ice and means that they are willing to trust you. The other thing to be really conscious of when you're conducting conferences in this way is to ensure that you are actually in a private space, because often what happens at the police station is that you are put onto a telephone with the defendant there. And I have had circumstances where I've had to check that the officer has actually left the room before I start to conduct the conference, because obviously we can't physically see each other. A young person might not be aware that that individual shouldn't be there when we're having a private conference. And so that's another barrier that that I have faced. And I now have a checklist of things that I go through before I can start conducting the conference. The first is to ensure that they know who I am, that I have spoken to their family members before speaking to them directly, and also that I have ensured that the line is secure before we start having a conference. The remote procedure is new to everybody, but it's particularly daunting for defendants who are under 18 and who have coming to the courts for the first time. They are extremely anxious, and just actually explaining the layout of the courtroom has really helped to break down some of those nerves that they have before coming before the court. Also, it's very difficult when you're on a telephone or on a video link to give instructions or take instructions in the same way. And so I tend to limit myself to the core parts when it comes to taking instructions on the phone, and then conduct a more detailed conference thereafter. And the most important thing then which I take are in relation to bail, because that is the most complicated part. It's where I have found that the biggest hurdles that I have faced are into making bail applications for youths. The reason that I say that is because the ordinary procedure for bail, I've got a flowchart there which isn't massively clear because it's quite small, but there are different stages for youths. The youth offending service that ordinarily play a particularly large role in helping secure bail packages, in my experience, have been thoroughly lacking. I have found extremely poor communication. Often they are just not at court, or they're there for only a limited period. And if you manage to get in touch with them, they are thoroughly unhelpful, often because they don't hold the information that they need in order to make those packages have those packages put together. I've also found that where you have a social worker involved because of the status of the youth, they are not communicating with each other at all. And I have found myself having to hold conferences between the social worker, the youth offending service, the family member and the client via Zoom in order to ensure that everybody is on the same page. But there is no unification or communication between those parties at present, in my experience. And there is also a real lack of willingness that I have experienced of both YOS and the social workers to conduct risk assessments of potential bail addresses. And that has actually hindered ability of the young people to get bail, and especially at the magistrates court stage. The way that I overcame that is to really utilise the role of the police liaison officer, who is present at court every time, and to have them conduct the relevant checks. And I have found that resource invaluable, because the police liaison officer is able to say that the address is suitable for bail or not suitable for bail by Googling an address. Of course, the risk assessment requires a physical attendance at the home, and that is a real barrier to ensuring that we get proper YOS support. Two clients of mine who were recently granted bail, both youths, had to overcome this hurdle, and despite my best efforts to sort of liaise between the parties, I found a real reluctance of both the YOS and the social worker to attend and conduct that assessment. And so it was only with the help of the police liaison officer that both of those were granted bail. There is a fairly essentially an extra layer of under LASPO that the court has to satisfy itself that it's necessary for the individual youth to be remanded into custody. And in terms of the specific requirement of necessity, there are of course several options. They could be remanded on unconditional bail, remand to local authority, or remand into custody, into youth detention. And I have been using the Court of Appeal's judgment, and I've just put it here at the end here, the Attorney General's reference in this particular case, which I've found invaluable. It really does relate to sentencing, but the principle that's been highlighted in yellow there, I think, is invaluable. And essentially what that says is that the current condition in prisons are a factor that should be taken into account when deciding whether to suspend a sentence. But also it highlights the fact that young people will be confined to their cells for about 23 hours a day, unable to receive visits, extremely anxious, and the impact of that is something that I have found useful when making submissions in relation to bail. I have also found that that magistrates, in the Magistrates Court particular, that submission seems to be given significant amount of weight, and where there is a possibility that sureties, for example, can be provided, the sureties being interviewed at court and being present at court on the day that the person is applying for bail has been particularly helpful. And so I would just emphasize that last point, that being able to point out the obvious in relation to your young person's vulnerability has been quite powerful. But don't rely necessarily on the ordinary court system to point that out for you. And also, I have found the lack of willingness from the Youth Offending Service and both social workers and the local authority in assisting has been really problematic. A final word on communication, which is that when conducting conferences, I have offered many more conferences than I ordinarily would, just as by means of reassurance. And I think that's really important, and I would encourage all practitioners to really think about creative ways to do those conferences, especially with young people. Thank you.
Thank you so much, Maryam. That was, I mean, really insightful. I mean, talk about, you know, news from the coal face, and talking about the procedural and the practice challenges that really are being faced by people trying to represent children during lockdown. That was extremely helpful. At this point, I'd just like to remind participants generally that if you do have questions, please do put them in the public chat, as that will be very useful for panelists to prepare answers, but also it means people might be inspired by your questions to ask their own. Now, I want to turn, I might, Maryam, if you don't mind, ask you to turn off your camera, if that was okay. Thank you. It's now my enormous pleasure to introduce someone who is not a colleague at Doughty Street, though given the level of engagement that she has with people at Doughty Street, she might as well be, one might say. But anyway, it's a real pleasure for us today to host Laura James from the Howard League. Laura has oversight of the Howard League legal service for people under 21 in prison, and as a result, you know, is enormously busy all the time, and has led really groundbreaking, crucial work focused on the rights of this group of children that, you know, are experiencing particular challenges and vulnerability in the context of COVID-19. In addition to her professional work, Laura has a professional doctorate in youth justice. She's a committee member of the Association of Prison Lawyers and the Legal Aid Practitioners Group. And if that wasn't enough, she's chair of the Legal Action Group. And in 2019, Laura was awarded Solicitor of the Year by the first 100 Years Inspirational Women in Law Awards. So firing on all cylinders, you know, practice, academia, policy, etc. Now, what I would, at this point though, what I think the really important thing to underline is the fantastic work that Laura and her colleagues at the Howard League have been doing over the last few months with regard to ensuring protection of children in a, you know, in a prison and in a prison context. And we're delighted to have her here today to speak to us about COVID-19 and children in custody. So over to you, Laura.
Good afternoon, and thank you so much for having me. I'm delighted to be here. So I will just start off very briefly talking about the Howard League for Penal Reform. We are the oldest penal reform charity in the world, it is said, founded in 1866, and we work to achieve less crime, safer communities, and fewer people in prison. And we try and do that through a mixture of policy, research, and direct legal work with young people. So we run a confidential helpline that's still running during the lockdown period. And we've been doing that remotely from home. It's been a huge challenge, but it means every morning of the week, young people can call and get straight through to a member of my specialist legal team. It's not just me, I have a team of amazing women working with me. We are a membership organisation, a very reasonably priced one, I should add, and we take no government funding. We also have a lawyers network, which has been hosted on many occasions by Doughty Street Chambers. So thank you also for that. More information on our website. So really building on what Maryam was talking about there, I just want to talk to you a little bit about what we are hearing from the children in prison right now. Every day we speak to children and they tell us exactly what the Lord Chief Justice was saying in the Manning case, that they are behind their door all day, getting stressed, not going to the gym. And they're also incredibly concerned about their families. Lots of our young people are very close to grandparents, and the concern, when you ask young people, what are you worried about? They almost always leap immediately to parents, grandparents, particularly at this anxious time. But the time in custody now really is characterized by this. This is what a young person described his time to me as last week: just waiting. And this is a young person who, prior to the COVID restrictions, was going out every day to college in the community, preparing for release after having been in custody for several years. All of that was stopped in a day. And another young person in a YOY described to me last week that he is always hungry. Obviously most young people in custody are teenage boys, and many of you will know that teenage boys like to eat and they have big appetites, and the meagre prison provisions are often not enough to keep them going. So they often rely on their canteen where they can order extra foods, tin fish, pot noodles, very popular. But those provisions have actually been restricted. So this young person says that he can only order a very small amount of pot noodles now, and he's sleeping, a child sleeping to forget about his hunger. So on the back of all of this and what children are telling us, we produced last month a briefing really setting out some of the issues affecting children, young people. And we did it actually for exactly the reason that Maryam just said. We want practitioners going to court day in, day out to have something that they could present to the court to say, you're not just imposing a custodial sentence, this is what you are sending children to. The regime in custody has been severely restricted since the 24th of March this year. That's 78 days and counting of children being in prolonged solitary confinement, according to the international definition. 15 plus days of spending 22 to 24 hours a day in your cell. That means exactly what we heard just now: no face-to-face visits, no education in almost all establishments except pretty much the secure children's homes, no therapy, no gym, and huge difficulties, just as Maryam described, in planning for release. And of course, the safeguards are hugely reduced. Previously, you would have children's rights advocates there on site, you would have social workers on site, you would have the inspectorate going in and out. Now we've just had 3 very short one-day scrutiny reports in one report based on 3 prisons. And those safeguards are essential because even before COVID, the situation in custody was dire. There has been a huge stream of independent reports outlining the dire situation of children in custody, but I'll just highlight 3. The inspectorate last year told us that 40% of boys in YLYs and 1/3 of children in secure training centres said they didn't feel safe. That's mainly, again, teenage boys admitting they don't feel safe. That's a big deal. And they're in the care of the state. In January of this year, the Chief Inspector produced a thematic report on the use of solitary confinement across a secure estate for children. And even at that time, and that's before all of them were essentially in solitary confinement, he outlined huge concerns about the harmful potential effects on mental health of solitary confinement. And the independent inquiry on child sexual abuse that reported last year said there were 1,000 incidents of alleged sexual abuse in less than a decade. The fact that we even have to have an independent inquiry on child sexual abuse in prisons says a lot. And the use of force and self-harm is at an all-time high. So restraint, and when we think about restraint, we have to think about what happened tragically to Adam Rickwood and Gareth Meyer over 15 years ago now. Restraint has increased by 16% in the last year alone. That's over 6,000 incidents. And self-harm has increased too. And both those measures are the highest number of incidents in the last 5 years. So sending a child to prison, whether it's on remand or whether it's for sentence, is a very serious thing to do. And all children are, of course, there because an adult has decided they need to be there. Now let's have a look at the numbers then. So the one good news story here is that the number of children has reduced. In fact, as we speak, it's, I think, at the lowest I've ever known it to be. It's around 700. When I first started doing this work, about 3,000 at any one time, 10,000 children going through the prison system every year. So it's reduced dramatically, but let's look at that reduction. The orange line at the bottom there is BAME children, and the dark blue line at the top is white children. And so what you can see is that the reduction has been a reduction in the number of white boys. So BMA children used to be approximately 1/4 of all children in prison, and now they account for 1/2. And I'm really pleased that Maryam's focusing on this situation in relation to remands, because that is critical. 1/3 of all children in prison are on remand. 2/3 of those children will not go on to get a prison sentence, either because they're acquitted or they'll get a community order. In the south of England, 2/3 of children approximately on remand are from minority communities. And most cases, as we know, have been delayed or postponed. So what we have is a situation where we've got the guidance that the Lord Chief gave us in Manning, which Maryam gave us. But there's no guidance actually in respect of remand decisions. And that's a huge opportunity for practitioners to get out there and get the kids out of jail. So we've produced this pack. It's free. It's available on our website. We're also doing a practical session for practitioners on all those community care rights and bringing in community care lawyers to get those safe packages out this time next Wednesday. We'll put details of that on our website if people are interested in taking that further, but it's an absolutely critical time. So finally, just to round up from me then, this shouldn't be the situation. We have no excuse to have to be talking about these things now. 3 years on from the Lamy review, why has the proportion of BAME children in prison increased as it has? 15 years on from the tragic deaths of Adam Rickwood and Gareth Myatt, why are children still being restrained and at an increased rate when we know the risks? And over 100 years on from the 1908 Children's Charter, which was designed to shut the prison door and open the door of hope and ensure special treatment for children, why are we still locking children up, especially now when all hope of welfare, education and training for children in custody has disappeared? That's it from me. Thank you.
Thank you so much for that, Laura. I mean, I think it's a fairly devastating account of, hungry, lonely children who are, subject to terrible conditions that seem to have been greatly exacerbated by the COVID-19 situation. It's utterly depressing to hear, and it just makes clear the importance of the work that the Howard League and, other people involved in today's webinar are involved in. And of course, the need to move forward with the inquiries and the findings that we already have in order to protect. I'm sure we'll come back to this issue, but one thing that obviously you have flagged and that has been flagged consistently when talking about issues around criminal justice and young people is the disproportionate impact on children from ethnic minorities, BAME children. And I'm sure there's questions about that. I can see in the chat. Just to say now, I'm going to turn now after I think what you will agree has been a superb set of presentations. We will now turn to Q&A. There are some questions already in the chat. Can I ask all the speakers, please, to turn on their cameras? Wonderful, so we can see you. And I am just going, for efficiency's sake, I will go through some of the questions. There was a question early on for Kirsty, which I'm just going to flag. She has efficiently answered it already. Thank you so much, Kirsty. And it's a question from Mohammed Shaib, and it was saying it was an excellent presentation, Kirsty. Can you kindly let us know if any action is taken or any fixed penalty notice has been issued against any children or child? And Kirsty's response was that fixed penalty notices can't be issued directly to children, but they're issued to the adult responsible, and that there were amends in the regulations on age over 18 to 18 and over. And there was a report of fixed penalty notices unlawfully issued to children in the early weeks of the lockdown, with 39 being issued between the 27th of March and the 13th of April. So that information is in the Q&A section. Thank you very much for that, Kirsty. I think I'm now, forgive me as I skip along here, as I move up to the questions. I think that the first question we have is, the first question we have in the chat is again aimed at Kirsty, is possibly, I'll give to Kirsty first to respond to, but other panelists will certainly have views too. This is from Elspeth Webb. And Elspeth is asking, is there any evidence that these powers are affecting children from vulnerable, e.g. ethnic minority, BAME groups, in temporary accommodation, etc., and or socioeconomically deprived groups? And if so, if there is this disproportionate impact, who are the groups most affected? Okay.
Yes. Well, the Metropolitan Police actually released figures which caught their headlines. They released them at the beginning of June. So obviously they looked at the London area, looking at proportionality or disproportionality with with the issuing to Black people, and also there was separate figures for those comprising the Asian community. And the figures are that in London, between the 27th of March and the 14th of May, there were 973 fixed penalty notices. And white people make up 59% of London's population. They received 444 of the fixed penalty notices, or 46% of the total. The key point here is that Black people, who make up 12% of London's population, received 253 of the fixed penalty notices, or 26%. Asian people make up 18%, received 23%. So there's a disproportionate application of fixed penalty notices to Black people. the reasons behind it, the explanation, as I recall from the Metropolitan Police at the time, was the reasons were complex, and we haven't been able to drill down any further into the data as to what's been released from them. They are often saying that they are caught, the fixed penalty notices are also issued together, or they were being issued together with suspicion of other offences that was connected to gang-related activity, which in turn was connected to black people within London. But there's nothing clear as yet, other than to say that those figures are a concern.
Thank you very much indeed, Kirsty. There was a further question about whether is there evidence within the wording of the Act of structure that suggests structural discrimination, or is it simply the way the police choose to implement the Act? My sense from your question is that it's really about implementation rather than the structure of the Act itself, but perhaps that's wrong.
Yes, no, that is right, Aoife. What happened, I sort of got quite involved as a practitioner really in these cases, since their introductions, purely through chance. And initially what was happening was the police were just mixing up the guidance that were given, not only through guidance from the police chiefs themselves, but government guidance. They were just mixing it up and thinking that was the law when it wasn't actually the law, because the guidance given was more restrictive than what was contained within the law, even though the law itself is extremely draconian and is the most draconian since the Second World War. So we then saw a huge number of unlawful charges, arrest charges, prosecutions being brought. That led to the Crown Prosecution Service by the end of May reviewing all of its charges under the coronavirus laws, both the Coronavirus Act and the regulations. And it was some 26 or 28% had actually of charges and prosecutions that have been wrongly, unlawfully brought, which was fairly astonishing. So the other aspect then seems to have been that there has been perhaps discretion incorporated by police in a way that is not being applied in an equal way. And we really saw that with the Dominic Cummings case, which got people very, very annoyed that there wasn't parity. And we're now getting cases coming through saying, actually, I think I had a reasonable excuse in the way that he said he had a reasonable excuse, but I got a fixed penalty notice.
Indeed. Maryam, I think you perhaps wanted to input on that as well.
I think I was going to respond to a different question,
excellent.
Yeah. What I would say, just one comment, which is that I have noticed in individuals who have I've been representing that are charged with offences under the Coronavirus Act and the regulations, that they have either mischarged them in the first instance, which is what Kirsty was highlighting from the very beginning, or that they have not even given them the opportunity to be given a fixed penalty notice, but have just charged them along with under the Act. And so there is a noticeable mistreatment or inconsistency in the way that these are being applied. And I do make the point that the people who I am representing that have been charged with offences and not offered the fixed penalty notices are invariably from Black and minority ethnic backgrounds. And I have noticed that in 4 cases that I have been involved in where coronavirus charges have been put.
I mean, that in itself is, the anecdotal evidence apparently compounding other forms of evidence that we're seeing. Thank you very much for that, Maryam.
Yeah, could I just add that just very briefly before we leave that? What's important as well, and I should have said, was that the police also and prosecutors were mixing up the Coronavirus Act with potentially infectious persons with the regulations, which were the prohibition on movement. And so people were being charged under the Coronavirus Act when it was absolutely nothing to do with being potentially infectious. And there was 44, so every charge under the Coronavirus Act was a wrongful charge. And so there was 44 of those which were set aside. So I should probably have made that clear as well. It's been a total mess.
That's great. No, thank you very much for that clarification, Kirsty. Well worth having. I now have a series of questions for Laura, and I'm giving you them together because I think they're interrelated. Debbie Nolan has asked, lovely surname there, Debbie. Laura, do you have details of how the population of children in custody has changed during COVID? Again, this may be something that Maryam and Kirsty want to input on afterwards. Second of all, from Emma Johnson, do we know why restraint has increased so much? Has there been an analysis of this? Maybe it's too early days, but maybe it's not. And finally, at this point, Laura, what are the key factors that are resulting in BME children going into custody at much higher rates? And that question is from Ravinder Barn at the Royal Holloway University of London. And I think that last question really builds on some of the things we've spoken about already. So maybe if you could unmute yourself, Laura, and address them first, that would be great. Yeah. Thank you.
I would do my best, just 3 small questions. So we don't know enough yet about the changing shape, as it were, of the child prison population. The latest breakdown data goes to March only, and that was just published this week. And we don't have the kind of granular detail of who's coming in. It's certainly at the lowest, as with all the rest of the courts haven't been sitting, so it's lower than usual. So I think it's too early to say who's coming in and what for, although I've got to say, you know, I've been representing children who are in for criminal damage, and and spending time in solitary confinement for really what I would regard as things where they shouldn't be going to prison at all. So we'll have to wait and see. Why are the restraints up? Again, we don't have enough detail about that. Some people say that, of course, it stands to reason that restraints would be up because violence and assaults are up. And that is true. But you have to see that in the context of what would you expect if you have an institution that is characterized almost culturally by violence. And I think that is a really important thing to remember. We don't really know exactly why restraint is up. There hasn't been any work on it, but it's obviously completely appalling and concerning. And many of the children that I work with, in fact, I was just talking to a child just before I came onto this seminar, who we were having exactly that conversation about how the child had a history of trauma, and the repetitive restraints just reinforce that. The third question, which is why are there so many, it's mainly young black boys, let's be honest about that, in custody, and why is the proportion so high? Again, although we have the amazing work of David Lammy now almost 4 years ago, we still don't have a grip on the reasons why. No one has actually been in and looked at the granular detail of who's going to prison and why. What we do know is that if the age group of children who are criminally responsible, if you like, or deemed to be criminally responsible between the ages of 10 and 17, approximately 18% of the wider population are from BME backgrounds. When it comes to the number of children who are arrested, that goes up to 23-25%, so around a quarter. And then when we get into custody, it's 50%. So something is happening between the point of arrest and the point of sentence and remand decisions to ramp those figures up. What we don't have, and I know that there is somebody from the CPS in the audience, what we don't have at the moment, and which we'd love to see, is data on prosecution. We need to see that, and then we need to know more about sentencing and why. I suspect the reason for it is probably what I call accumulated disadvantage, that children from minority communities are passed over and disadvantaged from the outset, and that just snowballs and continues and intensifies. And of course, we can't rule out institutional racism because it's there.
Thanks very much indeed now, Laura. The next question is for Maryam. And Maryam, it's from Keelan Gallagher, who is obviously the co-lead of the Children's Rights Group and a colleague at Doughty Street Chambers. Words I realise I'm using a lot today. But this is a question for you, Maryam, and it's very much, practice oriented. And Keelan is asking, as an advocate, do you find it more difficult to persuade the court to grant bail at a remote hearing? And Keelan says she's conscious of previous reports, not during COVID, that of defendants on video link finding it harder. So what's your experience with that, Maryam?
I would say in the magistrates' court, certainly, the communication is extremely poor. And there's also the inability to be able to just turn your back and check a fact or a detail, or something that is raised by the prosecution. So there is a serious hindrance in being able to fact check things with your your client, and that is massively a hindrance. And the stock submission that I've been making before I even start making bail applications is that we haven't had the opportunity to have a thorough and proper conference, and that should not prejudice the defendant in his or her bail application. And I have found that it's incredibly difficult to take every bit of information that you need in the conference that you have before you get into court. And in fact, during one bail hearing, there was a crucial piece of information about whether an address was available outside of London. And it was on that point that the district judge was going to grant bail or not. And so I actually requested that the court be emptied so that I could conduct a conference on this one specific point with the defendant inside the courtroom. And of course, that's not ideal. It's not completely secure. But what it meant was that I was able to take instructions on that particular point. And ordinarily, you would just be able to turn your back and check, you know, or be able to ask for a short adjournment or whatever it is. But there is definitely a loss of persuasiveness through the screen, and there's also an inability to communicate directly with the defendant that is really prohibitive. I'd also add that where you throw an interpreter into the mix, it starts to get really messy. And so I've often had issues with connection problems that the interpreter's having, that they dip in and out of the hearing. The overall effectiveness and persuasiveness is of course impacted by those issues that don't ordinarily apply. And so at the Magistrates Court level in particular, I have found it much more difficult. I would say in the Crown Court things tend to run more smoothly, and I have found that there is a greater willingness to grant bail anyway in the Crown Court, and that I would say that happens, you know, outside of these circumstances, but it's exacerbated at this stage, I would say.
Thank you very much, and I'm sorry now I'm sort of speeding through, but we have 4 minutes left and I want to try to get through as much as we can. Very quickly, we have a question from Leo Ratledge, who's with the Child Rights Information Network, CRIN, saying the COVID-specific release scheme itself has had no impact on the release of children, but have there been other routes for earlier release or avoiding detention that have been effective? That's one for you, Laura. I'm going to very quickly go down, and then I'm going to give each panelist a minute in which to address the questions that they can. Laura, another question for you. How can we support the Howard League? There's, you know, grab your moment. I've already circulated the website of the Howard League. There's a question by children in remand from Mohammed Traib. By children in remand, do we mean that children are kept in custody pending completion of investigation? Can they be granted bail in such a situation to avoid their confinement? There may be a very quick answer to that. And finally, from RB, who has a mysterious acronym, or else, you know, handles Zoom as well as I do, should policing be the key focus for social researchers? So I'm going to hand over to Laura, then Maryam, and then Kirsty. Just a minute each, summing up final points, both in response to the questions and emerging from today's conversation.
So thank you. In terms of the early release scheme, under the COVID provisions, it was a temporary release scheme, and it was really designed with adults in mind. Not a single child has been released under that scheme, and only I think 10 were ever deemed to be eligible in the first place. But absolutely, Leo, you're right. We've been thinking as creatively as possible about other ways to get children out of jail. At the Howard League, we've actually managed to get quite a few out through, whether it's through parole, release, and making all the arguments that we've talked about. And bail is absolutely a really important part of that. And on the question about remand, yes, that will be where somebody is either pending trial or sentenced, convicted but unsentenced, and yes, you can apply for bail, and that is what I think Maryam's been talking about a lot, and that's what our pack is there to do. What can you do to help? Well, the first thing is please look at the resources we've developed and use them, share them with all your practitioner colleagues, whether that's youth offending team workers or parents or other lawyers. So please, we've tried to sort of hand out the arguments, lots of the things that Maryam's talked about on a plate in those packs, load them up onto the system, use them, tell us if you want us to change them or improve them. And of course, you can always join the Howard League. I think I've already made that point. And finally, in relation to policing, you'll have seen yesterday the Home Affairs Committee has just issued an inquiry and a call for evidence due in by the end of this month on race and policing. I think we all need to engage in that. I think it is a really important area for research. The Howard League's been doing lots of work on policing and children, and actually that, if you saw the chart that I had where we looked at the reduction in number of children in custody, that's because there's been a 70% reduction in the number of children arrested in the last 7 years, and that is to do with police practice.
Thank you very much. Now, I'm afraid it's down to 45 seconds each for Maryam and Kirsty, but I think Laura covered an awful lot there, hopefully. So Maryam, take it away.
Just a very quick thing. By children in remand, if they're going to be remanded into custody, the judge has to make a decision about whether they're remanded into the care of the local authority or whether they're going to be sent to a young offenders institute. And they have to prove that it's necessary. There's a test of necessity that has to be satisfied before they're sent to a young offenders institute. So I hope that's clear.
Brilliant. Thank you so much. Kirsty, final words.
Final word. The Crown Prosecution Service carrying out a review of its charges, I thought was a really courageous step and should be applauded. I applauded it at the time. What needs to happen is that there should be a similar review of FPNs. There's over 17,000 that have been issued. There's evidence of many having been issued unlawfully, for example, to children. So that should happen. And just keep an eye out in the press tomorrow. There's another very concerning story which is going to hit the press tomorrow on an FPN also involving young children. On policing, yes, it's crucial to keep have a social engagement. It's meant to be policing by consent, and it's fantastic when you see policing doing that, and many do. What's been a concern for me has been signalling from the police chiefs in this kind of really old-fashioned macho tone, which has taken on the tone of the politicians. And I think that has caused a lot of confusion to the police as to how they should have been exercising their powers. The final addition I would make on custody time limits, which applies here, is that there's been a protocol which was issued and that is ripe for challenge, that the coronavirus pandemic is good and sufficient cause for custody time limits to keep on being extended. So again, there may be some legal challenges on that.
Listen, thank you all so much for fantastic presentations, fantastic inputs. I mean, thought-provoking, information-rich, certainly not uplifting, but showing us where the work needs to be done. And I mean, thank you for your time and your efforts. Thank you everyone who's participated today for all the questions. We will, of course, be uploading the webinar and the slides over the coming days. So do keep an eye on the website, as well as that for future events. But I know that we can't, because of Zoom, we're not able to clap properly. So I will clap very loudly, and I hope you will be clapping where you are as well. But thank you all very much, and we will see you at the next webinar. So thank you.
Thank you all.
Thank you.